Hello folks, welcome to the Wikipedia world and I am Abhinay Gupta. Today again we'll continue with the topic, the Sarfaesi Act 2002, which is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. So before starting with the chapter, we'll take a quick review of what we have done so far in our previous lectures, so that if there is anything that is yet uncovered for you, please refer back to the previous lectures, complete it so that we maintain the flow, right? So to start with, what we have done in the first lecture was the entire flow of the concept of securitization and reconstruction. We had seen the four basic elements: the obligor, the originator, the securitization and reconstruction company, and the qualified institutional buyers. And we had seen the relationship between all of them. Followed by that, we had covered the definitions of what securitization is, what reconstruction is, what are secure assets, what are financial assets, what is security receipt, what are schemes, etc. Right? And to reinform you and create the importance of the definitions, right, you have been asked direct questions to explain the terms, right? So followed by that, we had covered section 3, which talked about the registration of the securitization and reconstruction company, where we talked about the issue of the certificate, right? Then in section 4, we talked about the cancellation of the certificate of registration, right? And what are the circumstances that leads to the cancellation. That was followed by section 5, the acquisition of rights or interest in the financial asset by the securitization company. Then section 6, whereby they had to send a notice to the obligor. Then we had covered section 7, right, where we had seen the consequences if the financial assistance, the financial asset, is not realized by the securitization and reconstruction company, right? What are the actions that the qualified institutional buyers can take? Then section 8 taught us that the security receipt are not supposed to be registered. It is not a requirement for registration of the security receipt. Then in section 9, we had seen the various measures of asset reconstruction, how the securitization and reconstruction company reconstructs the financial asset that they have taken over, right? And most important of it being the enforcement of security interest, which was covered under section 13, right? And under section 10, what we had seen was the other functions of a securitization and reconstruction company. Followed by section 13 was section 15, where we talked about the manner and the effect of the takeover of the management, right, of the borrower, of the obligor, right? Then in section 16, we had seen that there is no compensation to the directors for the loss of office, right, when the management is taken over. And then in section 17, we'll talk about the right to appeal, and that will be the topic for the class today, right? We'll be covering section 17 and section 18 in the lecture today. So if we move on to section 17, what we see is the right to appeal. So the first thing is, who has the right and what is he going to appeal for? So for that, first we need to understand who is aggrieved, right? So if reconstruction of a financial asset is under process, then the secured creditor would forcefully, or by applying the, not forcefully, but applying the means and applying the procedures given under the securitization and the reconstruction, right? By that, they would acquire the asset of the obligor, right? Either by takeover of the management, acquiring the asset, appointing manager and stuff. All that we had seen in under section 9, right? We had seen the measures, and even under section 13 subsection 4, we had seen the various measures, right? So when the secured creditor, right, applies those particular measures that are mentioned in section 9 and section 13 upon the obligor in order to reconstruct the asset, the obligor can be aggrieved. And if the obligor is aggrieved, right, the obligor, the borrower, or any other person on his behalf can file an appeal to the debt recovery tribunal, right, against the measures taken by the secured creditor. And this process has to be initiated. This application has to be given within a period of 45 days. And they would also have to pay a certain amount of fees with the application. And the fees would be different for the borrower himself and for any other person applying on his behalf, right? And they will not be able to make any appeal to the debt recovery tribunal in the cases where they had made a representation, as we had already discussed, when they made a representation and the secured creditor had given them a valid reason for why the representation was rejected, right? And if that was lawful, then in that scenario they are not allowed to actually file an application to the debt recovery tribunal. Now, the borrower files an application to the debt recovery tribunal. And what will be the content of the application? They will apply to be secured, right? What they'll say is that the secured creditor is applying certain mean to reconstruct his asset, right? And that is something which is not beneficial for the borrower, right? That may have some hardship on the borrower. So the borrower appeals that these measures should be either curbed or stopped, that the secured creditor is undertaking, right? That has to be curbed or stopped. Now, what is the responsibility of the debt recovery tribunal? So the debt recovery tribunal on the first hand will check whether the measures adopted by the secured creditors are as per the provisions of the law, of the sections, right, as covered under section 9 or section 13, subsection 4, right? So if it is so there are two scenarios: either it is as per the provisions of the law, or it is not as per the provision of the law. So if it is as per the provision of the law, right, provisions of the act, then the debt recovery tribunal will set out an order in favor of the secured creditor. That, okay, if secured creditor is going ahead with such and such of the measures to reconstruct the asset, and that is lawful, that is as per the provisions of the act, then they would allow the secured creditor, like they shall entitle the secured creditor to recourse the action that they are taking, right, and the actions that are mentioned under section 13 subsection 4, right? But if in any scenario the debt recovery tribunal finds that the measure adopted are not as per the provisions of the act, like there is certain real hardship to the obligor, right, and the action taken by the secured creditor is not as per the provisions of the act, then they would declare the recourse to be invalid. So in that scenario, if for example the secured creditor is taking over the possession of the asset by some means that are not open to them as per the provisions of the act, right? So debt recovery tribunal in this scenario has the power to declare that action to be invalid. Hence the secured creditor would not be allowed to advance with that action, that set of actions, right? And if it does so, then it will be penalized. Then the matter will be looked into by the debt recovery tribunal in a different aspect altogether, right? So if the recourse is not as per the provisions of the act, then the debt recovery tribunal would require them to restore the management of the business to the borrower, right? Or restoration of the possession of the secured asset that the creditor has taken, like restoration of whatever action they have taken as per section 13 subsection 4, right? And they may also pass some additional orders if they deem fit. And where the recourse taken by the secured creditor was as per the provisions of the act, in that scenario, notwithstanding anything contained in any law for the time being in force, nothing would stand on their way, and the secured creditor would be entitled to carry forward with the recourse of the action, right? Now, whenever any application is made to the debt recovery tribunal, it would be the duty of the debt recovery tribunal to dispose of the matter in a period of 60 days, right? And this can further be extended, right, from time to time as per the requirement, but the maximum period that can be allowed, cumulative of all, right, for the settlement of any issue, for the settlement of any application made by the borrower would not exceed in any scenario more than 4 months, right? So that is the limit. You may extend it once or twice or thrice with whatever period you want, but in totality, right, in the aggregation, it should not exceed a period of 4 months. And in the scenario where the debt recovery tribunal is not able to dispose of the case, to dispose of the application within the prescribed time, right, even after the extension, then the matter can be raised to the higher level, and then appeal can be filed as per section 18, right? So in the next section we'll see who is the next level authority and how is the appeal to be filed and what are the procedures to be taken. So under section 17, right to appeal, what we have seen is that the borrower or any other person has the right to appeal against the recourse of the secured creditor within the period of 45 days, and then the debt recovery tribunal would assess whether the action is as per the provision of the Act. If it is, then notwithstanding anything contained in any law for the time being in force, that action would be valid. And if it is not as per the provisions of this Act, then he would declare the action to be invalid and would ask for restoration of whatever loss has been made, right? And then the Debt Recovery Tribunal has to dispose of the matter within 60 days and extend it to the maximum of 4 months cumulative, right? And if they're not able to dispose it on time, and if there is no further extension or the period of 4 months are over, then the case can be taken up to the higher authority, and that will be discussed under section 18, right?